All right, we are live. Hey, everybody, welcome to our conversation. I'm so excited to be here with two amazing, dynamic lawyers and scholars. All right, we are live. Hey, everybody, welcome to our conversation. I'm so excited. All right, we are live. Hey, everybody, welcome to our conversation. I'm so excited to be here with. All right, can you guys hear me? Amazing, dynamic lawyers and scholars. All right, we are live. Can you guys hear me? Hey, everybody. All right, great. So you guys can hear me right now?
Yes.
Not going on at once. All right, great. I had like too many windows open. So hello, everyone. Welcome to this conversation we're going to have today about Lady A, about the original Lady A, Anita White, Lady Antebellum. And I'm so excited to have two amazing lawyers with me and scholars to talk about these issues. The first thing I'll have them do is introduce themselves, and I'll introduce myself. Then we'll dive right in. So Alex, would you like to start?
Sure. I am Alex Roberts. I'm a professor at the University of New Hampshire School of Law. My expertise is in trademark law, so very fitting today. I also teach courses in entertainment law. I teach an undergrad course in pop culture and the law. So this is exactly the kind of stuff that I love talking about, and I'm excited to be here today.
Awesome. Anjali?
I'm Anjali Vats. I am an associate professor at Boston College in communication and African diaspora studies. I also have a courtesy appointment in the law school. So my area of specialty is actually race and rhetoric and law. And I teach classes in Black popular culture. I teach a class called Race, Law, and Media, and I teach critical race theory in the law school.
Awesome. And for those of you who are unfamiliar with me and my work, I'm Shontavia Johnson. I do a lot of different things. So where I like to sit is between entrepreneurship, intellectual property, and culture. I rant a lot, which is why I wanted Anjali and Alex here to bring me down a little, because this story in particular, when I saw it, 3 days ago on July 7th, I was pissed. And so I'm glad that we get to have an amazing conversation. If you have questions or comments, drop those in the comments below. And at the end, we'll do our best to answer some questions and walk through some of the things you guys are talking about too. So I want to start just by setting the stage for how we got here, because this story is so wild to me for so many different reasons. And so if you aren't familiar with this story, there's a woman in Seattle, Washington, who's a performer and entertainer. She's been performing since 1984 under the stage name Lady A. Her real name is Anita White, and has been performing, touring online, selling products and services. Fast forward to about 2 months ago, well, really fast forward to about April or May of 2020. And in the United States in particular, we have significant racial unrest right now, revolving around the extrajudicial killings of Black and brown men and women in the United States. And that's turned into a global international movement. And as part of this, many white people are realizing that they haven't taken enough steps to be anti-racist. Lady Antebellum apparently fell into that category, and they decided that in an effort to support Black lives and to support Black people, they were going to drop Antebellum from their name, which they've been performing with that name for more than a decade, and change their name to Lady A. And I think the first thing that really pisses me off about this story is that they only magically realized that Antebellum was connected to slavery and could potentially be offensive to folks. So at any rate, in June, on June 11th, they made this announcement that they were going to change their name to Lady A, which is a moniker that apparently their fans have been using for a while. And Alex will get into some of their trademark registrations that they own for Lady A. So they do this, I personally think, knowing about Lady A in Seattle, Washington. And obviously there was significant backlash around this, as Lady A, like many of us, woke up to that announcement on July 11th. And here we are, because that happened July 11th. They apparently enter into some conversations about how both parties are going to continue with the rest of their careers, as both of them want to use this stage name, Lady A, to perform. And there's so many things to unpack about this. I think the reason I wanted to have this conversation, particularly with both Alex and Anjali, is because I've been so concerned watching these protests and everything happening, and white people and white companies hashtagging Black Lives Matter and talking about supporting Black people when they have no history, pattern, or practice of doing so. And what we see here, I think, with Lady Antebellum is the quintessential example of that, right? Like changing their name to support Black lives, but ultimately, as of July 7th, filing a lawsuit to sue a Black woman for some of the same things they claim to be changing their name to support. And so I want to jump in. And one of the reasons I want to jump in first with you, Alex, is because there are a lot of bad legal takes on Twitter, on the internet, and everywhere else, just about what the real legal issues are and who even owns Lady A, if anybody, and how we can start to even frame the conversation from the standpoint of who has the right to use the word Lady A to refer to themselves. So Alex, could you talk a bit about what you see as the legal issues and how we can start to think about those things?
Yeah, absolutely. So I think there are two key points to cover. And the first is the lawsuit itself. And the second is the kind of issue of priority and of distribution of rights and who has the rights and what the rights look like to use this name in connection with musical performances and things like that, right? Mm-hmm. So, I very much agree with you that it's fascinating that this band either woke up one day and said, oops, we have a racist name we didn't even notice. Or more likely and more like companies like Aunt Jemima and Uncle Ben and owners of brands that are making these changes right now looked around and said the climate has shifted. We've been using this name for a while. We didn't want to let go of it because we've invested so much in it, but it seems like the tides are turning against us. People are going to have things to say and more people will be offended, right? As you said, maybe more white people who weren't paying attention before are paying attention now, or kind of across groups, people are more attuned to these issues. So, not in defense of the band, but I do want to explain what this lawsuit is, because I think when people hear lawsuit, when people hear the band is suing Ms. White over this trademark, what they assume from that, and logically, kind of obviously, what they assume is that the band is trying to take away her rights. The band is trying to silence her and get to a court decision that she's not even allowed to use her own name that she's been performing under for so many decades. That's not exactly the posture of this case. So this is more like a defensive lawsuit. This is just requesting a judgment affirming that the band's federal trademark rights are valid. I think that also will open a can of worms, or potentially may, right? When you're talking about whether one group's trademark rights are valid and somebody else has common law rights in play, which I'll talk more about, that may well lead to this broader discussion of who gets what and who can silence whom. But all they're really doing right now with this suit is to say, we are confident, we feel that we have evidence that Ms. White is about to sue us. And so we're going to be the first movers. We're going to be the ones to bring the suit so that we can choose the venue. We want to do it right here in Tennessee. Maybe that's a friendlier venue to us. We're going to set the timing. We feel like this is time for it to happen. We don't want it to drag along anymore. So they are making the first move, but in a sense, they're not coming after her. They're kind of doing this defensively.
Can I ask you a question about that point? So they filed this lawsuit, and to file a lawsuit, you have to say, I have a legitimate cause of action. And you alluded to the trademarks that Lady Antebellum has. Could you talk a bit about what they actually own and what Anita White owns?
Yeah, let me say one more thing first about the suit, which is the kind of funky jurisdictional issues in play. So like you said, there needs to be a legitimate cause of action. There needs to be a case or controversy and ripeness and all of those things. And those are maybe questionable here. So even under more recent cases like MedImmune, you need to have some kind of reasonable apprehension or some cause to believe that you are about to get sued. And Ms. White never made that threat. her lawyers did not explicitly say, if you don't do something, you're going to get sued next week. We're coming for you. Instead, all that happened was her new lawyers identified themselves as litigation counsel, maybe accidentally, doesn't seem like a big deal to me. They referenced a dispute. Obviously, there is a dispute. And in their discussions to try to her new firm came in with a money demand, and that demand was for $10 million. So based on that $10 million request, the band chose to view that not as a jumping off point for further negotiations to reach a number that would work for everybody, but instead as a threat of suit. And a court might not see it that way. A court might say, there's nothing here yet. You should just continue this conversation. And if you want to sue Ms. White for trademark infringement, or she wants to sue you, that's one thing, but you don't have enough yet for declaratory judgment. And then the other thing is that the personal jurisdiction is kind of interesting and feels a little bit like reaching, and I'm not a civil procedure expert, but they say, for example, that Ms. White participated in Zoom conference calls and phone calls with the band with the awareness that the band was in Tennessee when they had those calls. Like, okay, that's not really good enough. And then also that at some point, maybe she toured there, which is more promising, but still potentially questionable. Okay, so the question that you asked was about the band's ownership of federal registrations, right? Mm-hmm. The band has 3 different registrations on the principal register, and in fact, they are incontestable, which makes them really difficult to challenge. And usually means they have superior rights to any other user. So what this means in 2010, the band applied to register wordmark Lady A in a couple of different categories. I think one is musical recordings, one is entertainment services and performances, things like that. And one is apparel, which is so the kind of things you would expect from a band. Mm-hmm. Those of us who aren't big fans and haven't followed closely, there was a big reaction of like, what? They've never used Lady A. Nobody's ever heard of that before. But I think maybe more serious fans who have paid attention have understood this to be a nickname. And in any event, in applying for those registrations, the band attests to and signs a piece of paper saying this is our trademark. This is how we've used it. Here are some specimens proving that we use it and that we have since 2006, 2008. A couple of years even before they filed the applications. It looks like Ms. White started using Lady A first, as you said, like maybe as early as the early 80s. She was using that as her stage name. She was performing under that name. She's on Spotify. She's got albums, several albums, and they all say Lady A on them. So even though a federal registration, an incontestable federal registration, can be really difficult to beat, there's a possibility that her common law rights give her priority, make her the first user possibly in some of the country, but possibly across the entire country. And as you and I have discussed, that's a really fact-intensive inquiry that looks at things like where she performed and when, how she used her name, maybe on flyers, on publicity, advertising concerts, how she sold tangible albums and songs, and how she sold music over streaming services, and where those purchasers were located. So were they just in a couple of states? Were they in every state of the nation?
So could I interject one point here? And Anjali, I would love to get your thoughts about this. So as Alex is laying out the framework for the lawsuit, right? Like it sounds like Lady Antebellum has some pretty weak arguments even to get into court. It sounds like Anita White has priority even in this phrase Lady A, even though she never took steps to register the trademark. And it just reminds me of so many instances, particularly with people of color and Black creators and entertainers and entrepreneurs, of just getting lost in litigation, right? Like people using lawsuits as a weapon, not because they think they're right, but just to get you to stop doing what you're doing. And I'm wondering, like, what is the history, if you have any thoughts about like the history of this, particularly around like Black people and brown people and people of color, being really threatened in this way when there's little to no legal foundation for these kinds of lawsuits?
Sure. The sort of preemptive nature of this lawsuit reminded me immediately of Blurred Lines. It reminded me of and Robin Thicke, kind of became the centerpiece of that conversation, even though T.I. and Pharrell are technically co-authors on that song. But I think that's one thing, in just like an immediate pop culture sense that we have to think about, right? Like, what is this thing where you have white artists that think that they can preemptorily file a lawsuit to claim whatever rights they may or may not have, but as a wedge to not get sued, right? Like, does it make them right, or do they think it makes them right to speak first? So I think that's one thing. A second thing, though, that I would point out is that actually sometimes it's not about even the litigation at all, right? So there's this long history of just formally excluding Black and brown people from owning property in the United States. So in the context, if we were talking about copyright law, if we're talking about the ownership of the rights to the music, right, which doesn't seem to be an issue here with Lady A. You just have, what you have is a long history through jazz and blues of Black people getting pushed around and not being able to own their music. So KJ Green writes about this long history of unequal contract negotiations and so on. So I think there's two spaces there where we can really think about how race plays out. And I would argue that's fundamentally about property, right? It's about how white artists and white people more generally think about property and their right to kind of engage in these property games in a way that's exclusionary and not very beneficial for Black and brown people.
Yeah, and that has happened over time, historically, over and over again. There's this amazing article that came out yesterday in Vulture about this whole thing, and I'll drop it in the chat for those of you who are interested in reading it. But the author of that piece, and I've got to find her name because I just thought it was so well done, Andrea Williams. She talks about this, about like, you swoop in, you discover R&B, you discover jazz, and you co-opt it into country music, into rock, into everything else. And now you also, in addition to discovering it and co-opting it, you want to privatize and own it in a way that excludes the very people who created it. And that is another thing that really just like grinds me about all of this. That, I mean, I don't know that much about Lady Antebellum's music, but I know country music fundamentally is founded on the sound of jazz and blues and things that were historically created by Black artists. And I'm just so annoyed by that historical framing of even how we get here talking about trademarks. And so going back to this trademark point, Alex, we've got this litigation that now is underway, lawsuit filed July 7th. You talk about some of the issues that have arisen. What do you see as like the critical decision that will happen right now around this lawsuit?
I mean, I think the lawsuit was a mistake. I think for some of the reasons Anjali pointed to, and I love lawyers, I teach lawyers, I want lawyers to have plenty to do and earn an income. But throwing all of this money at lawyers is just kind of setting it on fire when these artists seemed, at least in the public eye, they seemed to be on a path toward continued coexistence. So it seemed like both parties were at one point looking at each other saying, you know what, we've coexisted for a long time. For the band, it wasn't their primary name, but it was something that they were using in some ways. And obviously, Ms. White was performing as Lady A for decades, and she was on Spotify, and nobody seemed particularly confused. And given these kind of conflicting rights, the registered rights versus the common law rights, I don't really foresee a court going all one way or all the other, saying one of you has exclusive rights to this name and the other one can't ever use it at all. If this were litigated all the way to decision, my expectation would be some form of continued coexistence, which is why I wish that both sides had worked harder to stay on track. It's unclear if like the lawyers threw them off, made them too adversarial, or if during that conversation, if the band did some of the behaviors that Anjali was just talking about, kind of acted like magnanimously, we'll let you keep using your name, and here are all the restrictions on that. And I think that's very possible too. And we see some kind of hints in the complaint. And again, this could be totally lawyer driven, but for example, the band maintains throughout the complaint that Ms. White has never used Lady A as a trademark at all in any way in any industry, which is a pretty aggressive claim to make when she's a musical artist and they're musical artists and they're kind of using it in the same ways in the same industries. So all that said, even though the suit has been filed, my hope and I think my prediction would be that they rein it back in, that they come back to the negotiating table and figure something out.
Yeah, and that's common with intellectual property litigation, right? Like very few things get all the way to decision. There are a lot of steps in between before you get to some outcome in a lawsuit. And I love that you brought up how we got here, because it started out with this name change, then this Zoom conversation. This Vulture article by Andrea Williams talks about how when Anita White jumped into the Zoom conversation, she could immediately see they didn't really care about her, and that they were more concerned about getting a picture that they could post online to show, hey, look at us being good allies, right? And that happens so frequently that people want to have the appearance of allyship, but not actually be allies. And Anjali, you write a lot about race and IP and the intersection between these things. What do you see as important to keep in mind as this continues? And like Alex said, like, why did we even file a lawsuit, right? Mm-hmm. But what are the ways in which race will drive this conversation and this decision and all the different things that are happening?
Mm-hmm. I think that allyship question that you bring up is really the heart of what is worth talking about here, in terms of like the practical racial implications for other people, right? Like what lesson can we learn from this? Don't be a performative ally or don't be a bad ally, right? Mm-hmm. I think one of the funniest things I read on Twitter that just hits the nail on the head was like, Lady Antebellum should rename themselves to Lady Anti-BLM. And it feels like that captures the whole affect, right, of what's happening here. So, I want to start with the question of what performative allyship means, because I think that that's not necessarily something that comes up in law school very often. But there's the question of, what do we say that we want in terms of race? And then the question of what do we do about our commitments to race or racial justice. And here you have this band that's like, oh my goodness, we had no idea that Antebellum could possibly be racist, right? Which is just profoundly unbelievable. In the same way that people discovering that Aunt Jemima is suddenly racist is unbelievable. But this band is like, we had no idea, and we definitely for sure want to change this now. And so they changed their name to a name that a Black person has already been using, that even though they had technical rights to, I think was what I would call a shining example of just because you can do something doesn't mean you should do it, right? And so they have decided that they're gonna change this name to this, and I think she identifies Anita White as blues and funk and jazz, like in that realm of music that has a history in Black communities in the South in particular. And then they're going to file this lawsuit, and they're like, oh, actually, we're not going to try to stop you from using this mark. We just want our rights to use it, as though she is asking them for something unreasonable. And the thing she's asking them for is compensation, right? She's asking them for $10 million. Now, I think Alex raises the question of, the issue here is not really, is $10 million reasonable or not reasonable? It's, are you willing to come to the table as a good faith actor and have the conversation about compensation? And I think the way that Lady Antebellum, I will call them just for clarity's sake here, the way they read as these folks that just don't want to pay money to use these rights, even though there is this Black artist that has been using this name as her livelihood, right? And so she comments on that. She says, this is my life. And she feels disrespected, right? And so if somebody feels disrespected, you are not doing your allyship right. Like something has gone wrong here. And when
you go on a t-shirt,
right? And she says this. She says that their camp is trying to erase me, and the lawsuit really does reek of that, right? And so when we talk about performative allyship, I think we have to talk about how all of these different actions read in a larger context of race, and whether it looks like the actions of the band align with the words of the band. And she puts it best when she says, "Think again, colonizer." She's like, definitely they do not align.
Right. And they put out this statement. I don't know if it was a Billboard or somewhere. They say, "We hope Anita and her advisors are willing to listen and change their minds about their approach." Mm-hmm. And that's so condescending in so many ways.
Condescending.
But particularly, I want to talk about money a bit, because the $10 million request, right? Like looking at it at that number, maybe it sounds like a big number, maybe it doesn't. This is a woman who has a 30+ year history in the industry. And one of the things she said was, "Hey, Lady Antebellum, you said you changed your name because you want to support Black people, you want to be allies, you want to move forward in a way that is culturally competent. Give me $10 million, and what I'm going to do is take $5 million and donate to Black people, Black causes, Black content creators. $5 million is for me, $5 million is for apparently all these other things." And so it's not even just that they don't want to pay money. They know what she wants to do with this money, to actually make them put their money where their mouth is, and they're just not willing to do that. And I'm annoyed by that for so many reasons. Alex?
I think the power dynamic is really interesting here. This kind of huge band that has a reputation, clearly a national reputation. Everybody's heard of them, I think, even if they have never heard their music, versus this kind of smaller independent artist who maybe has a very specific following but isn't as broadly known. And on the one hand, they're saying, they said, "We want to work with you. We want to collaborate. Let's write a song together. Let's, tour together, whatever it is. We can have a beautiful relationship." And then they tease that again in the complaint. Like, we thought we could boost up this person's career and really help her, but now she's not accepting that help.
Right.
But on the other hand, I think part of what the 10 million represents is the harm to her brand that happens with this name change, right? So sure, they had these federal registrations, maybe they had these rights on paper, and they kind of used Lady A as a nickname for themselves on their website, but it wasn't really the band's name, it wasn't in broad use. And when it, assuming they move forward and they use it really broadly, and this is their new name, it is going to crowd her out in a sense. It's going to make her harder to find. If you're looking for her music, looking for her albums, it makes her harder to find. And so I think that asking to put a dollar sign on that is not outrageous from a trademark perspective, as well as from a kind of social justice perspective.
Yeah. And so, oh, sorry, go ahead, Anjali.
Oh, I just wanted to circle back to this idea in the context of blurred lines. There were a lot of folks after that case. So if folks are not familiar with that case, what ended up happening was one of the largest jury verdicts in history for Marvin Gaye's estate for this song that sounded an awful lot like something that Marvin Gaye had written, right? And so we could go back and forth on the legal issue in that case about whether or not it was an overstretch to find copyright infringement there. But, this, I think, points to the question of what reparation looks like when you're talking about this kind of racial harm, right? So in that case, I was kind of like, if Marvin Gaye's estate is getting a bunch more money, cool. Like we don't want downstream bad effects for Black and brown creators where they end up paying more, but I am not it's not keeping me up at night, like worrying about whether Lady A is getting too much money for this mark that she has been using, right? Like if the woman wants $10 million and you've been repping the Confederate South for years and years, like I'm like, maybe you should give her the money. And it's totally okay to give her the money, right? So that also, I think, gets to this question of like, what does it mean to be a good faith actor about money? And what does it mean to not hoard money? In the context of racial justice, right? Like,
right. And like the harm to her brand, as I understand it, so Lady Antebellum changes their name, June 11th or something. They enter in these negotiations. So it hasn't even been a month yet. And within these past 3 weeks, when you search for Lady A, the original Lady A is pushed way down on the search results. If you look for her music on Spotify, she comes down the list after both Lady A and Lady Antebellum. Whereas before, I think she was higher in those search results. She said she's got a new single coming out or a new album or something coming out. And she tried to upload her single into these different platforms and she couldn't even verify her name for days because this group has decided to use the name over the past 3 weeks. And she was intending to release this single or release this album or whatever it is and have a kind of like a press tour and all these other things. And now it's just buried beneath a lot of Lady Antebellum stuff. And so there is real harm, right, to her around them choosing this path. And then just the other thing I want to touch on, and you're both professors, you teach students, you teach law students. I know, Anjali, you teach students outside the law school too. And I mean, I'm annoyed with the lawyers too, right? Like this is why it is so important to have cultural competence as a practicing lawyer. So no matter what the conversation was before, when it was just the band and the singer or whatever was going on, like, do we have an obligation as academics, as scholars, as teachers to bring race and bring these concepts into the classroom? So I am in the academic universe too. I don't teach anymore, but I'm still in higher ed. And there are a lot of people who think race doesn't belong in the classroom, but here's a perfect example of why practicing lawyers need to have cultural competence. And Alex, I know you do a lot of this in your classes. I see it on Twitter all the time. And I wonder your thoughts about this, about training students and future lawyers and future agents or whoever to be more culturally competent around these issues.
Yeah, thank you. I don't know. I don't think I do enough of it yet, but I want to try. I'm ready to try. I maybe fall into the category of one of those white people who has found the last couple of months really eye-opening and educational. So I'm trying to listen and learn more. Our faculty just passed a resolution actually this week committing to address systemic racism and work on diversity and inclusion in all of our classes across the curriculum and in our pedagogy. I think it's crucial to train lawyers with that cultural competence. And frankly, when I read these facts in this complaint, my thought, and this may or may not be true, but my expectation is like that the band had some lawyers who said, look, here's the position that you're in. You've got 3 incontestable federal registrations, and yet this woman is saying to you that you can either pay her $10 million or pick a new name. And if you don't like those choices, then you better sue, right? And that is not the way that I would frame the situation to the band. And I hope that's not the advice that they got, but the path that they took leads me to guess that it could be, right? So this kind of focus on these are your rights and you're being kind of victimized. I mean, to come forward with this declaratory judgment request, the way that Robin Thicke did, as Anjali said, like that's the taking the victim seat. That's saying like, we're being bullied. And so we just want the court to clarify that we didn't do anything wrong, right? Our rights are strong. And then we can enforce those rights later once you confirm for us that we have them. And so lawyers are not PR professionals. They're not, psychologists, but they do need to have those skills. Those skills are really crucial. And I think especially when you're working with entertainment clients, you've got to have the context in mind. You've got to have the ability to think about the specific people involved and the reputational interests of your client.
Mm-hmm. 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 Yeah, Anjali, I love that you brought that up, right? Like just reading the complaint, it sounds, they sound like assholes in the complaint, right? The way the language is written, the way they talk about this entertainer, knowing that these allegations are tenuous at best, right? And I just wonder about why it is about whiteness in particular, this desire to never be wrong, right? Like we live in this world where white people who are descendants of slaves say, oh, that was my ancestors, that has nothing to do with me. We need to just move forward.
Mm-hmm.
We do these things, right? Like we file these lawsuits against Black people, but we're not doing anything wrong. We just want to be right. So why is that? What is this about?
Just to be clear, did you ask me why white people do things like file these lawsuits? Is that the question on the table?
Not wanting to be wrong, like wanting to say, oh, you're doing a good job.
Yeah.
That just seems to be
absolutely
right.
Yep. Yeah, I think this gets us back to actually a more basic property conversation. So one of the reasons I do the work that I do, and to your last question, yes, the answer is absolutely yes. We need to talk about racial competency and gender and disability and all these things in law school, is that I remember sitting in law school, circa 2003, and we were learning about Johnson versus McIntosh. And that, of course, is the case where essentially the Supreme Court decides that Europeans have more recognizable land title, right? Because they came up with property law than indigenous peoples do. And I'm reading this case and I'm like, are we going to talk about the fact that this is real racist? No, absolutely not, right? And so I think that there is just this this sense that the country is built on, that property makes right. Like if you have the property right, that the thing is yours, right? And so I think that the way that the architecture of property rights in this country is built is around whiteness. And of course, the Cheryl Harris's famous law review article, Whiteness is Property, traces this argument through 200 years, that that a lot of what we're talking about is about who feels entitled to property, who feels entitled to have things, and who doesn't feel entitled to have things. So there's a sense here to me when I'm reading the band I'm reading what the band's actions are, of how dare she ask us for something, right? Like she should be grateful that we're not suing her for exclusive rights to the name. Like that's kind of the air of the whole complaint, to me, at least. So I would say that part of this is just built into the architecture of our legal system, that it is about entitlement, it's about ownership, it's about who gets to do the asking and who is supposed to kind of fall in line as it relates to that asking.
So what are the lessons here? For lawyers, for creators, for entertainers? Obviously, this is one moment in time. Next week, there'll be some new controversy. But what are the lessons we can take from these past few days of conversation around ownership, around trademarks, around creating? What do you guys think about that? What do we do with all of this? The rest of us, what do the rest of us do with all of this?
So I think the biggest lesson is about performative allyship, that we really need to be mindful as these racial justice actions are unfolding about the consistency between our words and our actions. And that if we're really trying to be advocates for racial justice, that it is important to act in ways that actually align with the interests of Black and Brown people in this country. So at a meta level, if people look at this case and they say, I can't see why this is performative allyship, it might be a good idea to go back to the case and listen to some more people and maybe have some conversations about why what happened here was problematic. And if that is legible, I would argue that it is a useful case study in what it looks like to do performative allyship. And that can teach us a lot about how we should behave in the day-to-day.
No, I love that. I mean, so many companies a few months ago, hashtag Black Lives Matter, posted a little black square on their Instagram page. And immediately people who had worked in those companies or dealt with those companies said, wait a minute, that is not really the way you feel. And I'm looking at like the San Francisco 49ers, hashtagging Black Lives Matter, right? Like, I love that point. So this is a lesson for all of you who want to be allies and who claim to be allies, but know that there's a lot behind the curtain that you have to deal with. And you have to be willing to give something up, right? Like it's going to hurt a little bit. It's going to hurt to be a good ally sometimes. And you just have to be okay with that. Imagine what it's like to be Black and brown in this country and have to deal with the subjugation, the racism, the many different things that we deal with day in and day out. What about you, Alex? What other lessons do you think there are?
Yeah, I mean, I was kind of going back to your like, why are white people question, and around privilege and performative allyship, what you just said, Shontavia, is what I've been thinking about, that, you know, the performative piece is easy, the speaking up piece is easy, but the actually giving away or giving up or saying, you know, I have to let go of some of this stuff that I feel truly entitled to, that piece is really, really hard. And just getting to the point of understanding that those things go together, right? That if you're gonna talk the talk, and the talk is unequal distribution and disparate treatment and things like that, then you have to be able to say, in this example for a band like this, even if you had ironclad rights, even if you had every ability to enforce them and it wasn't even in question, to say, we're gonna give some of that away, we're gonna walk away from this name, even if that costs us money, costs us goodwill, right? Or we're gonna do for this Black artist, not just because it boosts us up, not just because it will earn us money and will earn us acclaim and will get us praise if we tour together and we collaborate on a song, but giving away some of what we've amassed, that piece is a really big hurdle, I think, for so many people. And then on the other side, and I hope this doesn't sound like victim blaming, and I don't think it should, Shontavia, you've been a really big and vocal advocate for Black and brown independent artists, creators, entrepreneurs to get legal assistance, to register their trademarks, to register their copyrights, to take those actions that they don't always know are available to them, or you know they're not aware of, or they just haven't felt obligated to do. But to kind of take those affirmative steps so that stories like these become a little bit less frequent. And I think those of us who do pro bono work and who do, you know, clinics and who just are, I think, out there speaking up, we can do a lot of work in making sure that those kind of independent creators can get the help that they need.
Yes, so I'm so glad you said that, because and I am very transparent about this. I believe ownership is everything. And either you own the thing or the thing owns you. And if the thing owns you, this is what happens, right? And again, not to victim blame at all, but creators, we often think, okay, I'm creating in my little bubble, I'm posting on Instagram, I made travel, I made this, I made that. But we don't take all the steps that we need to take to truly be able to own the things that we've created. And there's a long history in this country, particularly with Black and brown creators, of not doing these things. And there are many reasons why. Some of it is lack of access, lack of knowledge, lack of resources, so many different things. But I think for me, this is one of the big things. The American Bar Association, the National Bar Association, our state and local bar associations, who have deep rosters of people who can support this kind of work. Like so many people are looking around like, well, what do we do? How do we help Black people? We don't know what to do. Like this, to Anjali's point, like this is a tangible form of reparations, right?
Absolutely.
To assist Black and Brown creators in pursuing intellectual property protection for the things that other people have been monetizing for years. And I mean, both of you know, and if there are any other IP lawyers watching this right now, you know it's really expensive, it's time consuming, it's hard, it's intimidating. And not just for Black and Brown folks, but especially, I've heard the founder of Spanx, what is her name, Sarah Blakely, talk about how when she invented Spanx, she wanted to find a woman patent lawyer to help her. But at the time that she was doing it, there was not a woman patent lawyer in the state of Georgia.
Oh, goodness.
And the male patent lawyers laughed her out of their office, or they laughed first and said, oh, give us $10,000 and we'll file this little silly patent application for you. And so I feel strongly too, when we're talking about training lawyers, I was a law professor for many years, both of you teach law students. Like you have to teach lawyers how to be culturally aware of what is happening with their clients. There are two other of our colleagues, some of you know one of them really well, Tanya Evans, Yolanda King, and I, we wrote this article about why it's so important to diversify the field of intellectual property law. And this is one reason right here, right? Like it's intimidating to go into a big law firm and say, hey, you know, $800 an hour partner, can you help me file my trademark application, if you even know to do that. And so I think the legal profession in particular has a strong responsibility, not just because of this story, but just because of the exclusionary nature of the IP field. It's one of the whitest legal professions in this country, in the United States, to do better, to really affirmatively do better as it relates to providing access to the resources people need to take advantage of the thing that built this country. I mean, like the Article 1, Section 8, Clause 8 of the Constitution, the intellectual property clause in the Constitution was one of the first things written into the Constitution, because IP is what made the United States, you know, go from a scrappy upstart to a dominant global economic superpower. And I think this is one small instance of why it's so important to be accessible, why it's so important for IP to be accessible. So any final thoughts from you all about what happens next, about this whole conversation before we jump off? Anjali, do you have any final comments or thoughts?
Well, I guess my final thought is about watching what happens in the intellectual property world and more generally in terms of racial justice. So you started off, or I think you or Alex started off by talking about all the trademarks that are falling right now, to use that monuments must fall sort of analogy. So I'm really interested to see what companies go next and what it looks like, right? Everyone's got their eye on that Washington football team in terms of what they're going to do with their trademark. So I am interested to see who follows and what it looks like when they follow and how well they accomplish their task. Are we going to have more Lady A's or are we going to have more kind of respectful situations that actually give Black and Brown creators their due and actually perform the allyship in ways that support the communities that have been exploited for so long? Yeah,
I mean, I think there will be more, unfortunately, Lady A's and Lady Antebellums. There'll be more Big Mama Thorntons and Elvis Presleys. There'll be more podcast issues like with The Knot and Another Round and BuzzFeed and Gimlet Media. There will be those things. But to your point, I hope we see less of them over time, right? What about you, Alex? Any final thoughts or comments?
I'm really interested in the role of social media and in the role of kind of pushback from the entire population, right? So I think that we're seeing monuments and trademarks and these kind of commercial markers fall, not just because brands and trademark owners are reading the room at a really high level, but because like people are getting out there and they're speaking up and they're pushing hard and they're talking about boycotts. And what's interesting about this case is to see that play out, not just with the name, right? Not just, hey, have you thought about what antebellum really means? Also with the action. So people are paying attention and people are judging and kind of saying, how dare you? And I think that's a great trend. And I think what it means is that the trademark owners and the others thinking about enforcing these rights or making these changes have to take that public sentiment into account. And it is powerful that people have a voice and can and do use that voice.
Yeah, and I will say I used to feel somewhat negatively about crowdsourced outrage, because I feel like, you know, the court of public opinion is harsh. No matter what happens in a courtroom, you know, it can be harsh when people get it wrong, and there are many instances of people getting it wrong. But I think, to your point, there's been a real benefit to crowdsourcing discontent, crowdsourcing anti-racist beliefs and activities. And I hope we see that trend moving in that direction, a positive trend toward holding people accountable for the things that they say. And yeah, I just do. So I love this conversation. I'm so grateful to both of you. I didn't do much ranting, a little, not a lot, but I really appreciate both of you spending some time with me. Thank you to all of you who watched. I'll drop some links to the things Alex and Anjali mentioned in the comments below, in the notes below. Anjali has a new book coming out about IP and race. I know Alex is always doing things around these topics of pop culture and intellectual property. I'll drop some links below so that you can find them, follow them. Make sure that you also hit the subscribe button. I do a lot of ranting about pop culture and IP. I also talk about entrepreneurship and the ways in which we can learn from pop culture as we build our own personal brands and businesses. Thank you both so much. I appreciate your time.
Thank you so much.
All right, y'all.